Hello, and welcome to another edition of Coffee Talk with Innovation and Trying to Learn. In this particular episode, I'd like to talk a little about wills. And let me just clarify when I say integration training. Of course, I've been doing that for over 20 years, and as I've discussed in other videos, once the client gets their green card and or citizenship, then we move on to estate planning to protect them for all the hard work that they've done to protect themselves, their spouse, their children, and in some cases, to even designate what goes to the grandchildren. So either way, that's where we are. So I'd like to just discuss a bit about wills. Many times when someone does estate planning, what they do is they'll either do just a will, when they're doing it themselves, they'll either do just a will or they'll do just a trust. But it's possible certainly to do both, depending on the situation. And sometimes it's recommended, sometimes it's not. For a will, the easiest type of will, which doesn't necessarily convey what you want, but if it's done properly, and I call it a perfect will allow you to very quickly write out what you want and to get lucky. And then, of course, you sign it. It has to be in your own handwriting, and then that takes care of the will. And naturally, estate planning is a bit more complicated than that, but that is a quick and easy way to do it. Now, there's also what many people have heard through, friends and family, television, books, the last will and testament, and that's basically what it is. Unlike a living trust, which can continually be revocable and changes and so forth. Once the will is done, it does become your last will and testament. Now, that doesn't mean that you cannot file amendments and changes to the will, and what that's called are codicils. Okay, so if something happens where you either sold property or you didn't sell property, or you don't want someone to, for example, be a guardian or your minor children, we sometimes just put in the will. You can, of course, do a codicil, which essentially keeps the last will and testament intact, but it changes or amends or adds or deletes whatever the purpose is of the codicil. Okay, so if that's all done properly, we can go forward. Now, in regards to the will itself, there's all kinds of provisions that can go in the will, of which, essentially is why you need a lawyer, a estate planning lawyer, to help you do it. But, there's declarations concerning your family. Sometimes you don't want anything to go to a particular person or group of people, and you can specify that in there. So if they ever try to dispute that you just forgot about them or you didn't have the mental capacity, they can still do that. At least if you have in who you want, what you want to go to whom, and also what you don't want to go to other people, it does make your intention quite clear. So that's why, if you omit a spouse or a partner or children, and you specifically say in the will why you're doing that or that you are doing that, that does alleviate your intentions as far as that goes. Now, there's also all provisions regarding property characterization, regarding whether it's community or separate property, and just so you know, just putting that in the will doesn't really change the characterization of the property. You can't turn, for example, separate property into community property only because you put it in the will. However, if you do put in the will a nice organized list of what property there is, which falls under the separate property, for example, which falls under separate property of the husband, which falls under the separate property of the wife, which falls under the community property of both, which are gifts and so forth, and where they are to go. It makes it much clearer how you want to devise your property and where you want it to go. Again, you can also have a specific provision in there regarding guardianship. So what's going to happen if you don't have that either here or in other estate planning devices is if you and your spouse die or become incapacitated while you still have minor children and you haven't designated who's going to be the guardian, then a conservator will have to be appointed by the court. And that might be someone who you don't like, someone you may not even know, who's ending up taking decisions and essentially medical and financial in raising your child during either your incapacity or after you die that has nothing to do with your intentions or what you wanted. So you want to make sure that if all you're doing is a will, or if you're doing a will on a trust, that you do have the guardianship provision in there, so that if these events happen, somebody you know who knows your children, loves your children, and is able to take care of your children will do so. Of course, you want to inform them before, so you don't end up with someone, not wanting to be a guardian. Okay, so along with these, you can have funeral and burial instructions within the will to make it easier on the person who is going to be executing the will. You can also designate who is going to be the executor. You want to think hard and fast about this. Make sure that you don't designate either somebody who has no interest in being an executor, or perhaps you want to designate more than one person to be an executor, which that itself could lead to a lot of problems, because one of the co-executors might have in their mind what they want, another co-executor might have in their mind what they want, they might disagree on the provisions, there might be some ambiguities. So, generally when I'm doing the trusts and the wills for clients, we try to get down to one person to designate, so that there's not this inherent conflict that exists when you designate more than one person. So there are lots of different other provisions that can go on a will. It's not set in stone. Even talking about your pets in the will. There's all kinds of things, but I just want to stress here that it is important to have a properly drafted will in order to go forward. One type of will is called the plurality will, and this is the one that exists in conjunction with the living trust, where you designate some things in the will to happen, and whatever doesn't get devised or distributed per the will pours over into the trust. Okay, I mean, it's not like you're actually pouring water, but in turn is that it will have all the remainder and everything that hasn't been included or devised go into the trust, and then the trust instrument itself will be able to handle all of the items that pour over into it from the will. Okay, so that's just the summary of the will, giving you some ideas. If you like the video, click like, subscribe. I usually do 1 or 2 videos a week, some on immigration, some on estate planning, depending where you happen to be, and then we'll go from there. You can also call my office for a free consultation or email me directly. Okay, more in the coming videos.